You can almost always get away with lying very, very blatantly to the court. But you should remember that if your lies are caught, there is a small percent chance, but that chance exists nonetheless, that your lie, if caught, will also be severely reprimanded by the judge, or worse, you may suffer some consequences as well. Very, very recently, I was arguing an anticipatory bail application before the Delhi High Court, where the court asked, what is the status of the call recording submitted by the complainant in the matter? When the complainant said that I have these call recordings, to which the investigating officer blatantly just blurted out, I have not received any such call recordings. To which the complainant at that point of time, a little vigilant, immediately took out their WhatsApp and showed to the court, pointed towards the court and showed that this was the particular date around 3-4 months ago on which I had sent on WhatsApp these audio recordings to the investigating officer. Now, even in this situation, if we pause here for a moment, I would say about 50% of the judges would not even think twice, would just let it slide because they think investigating officers are overworked, overburdened all the time, and we will not get into any sort of controversy as to whether this was deliberate or whether this was just a foolish mistake or a transgression or an oversight. About, I would say, around 40% of the time, at that moment itself, the judge will reprimand the investigating officer or an advocate who made an incorrect submission and say that you need to be more careful in the future. It is only about 10% of the times when your lie is very, very blatantly out there, it is caught and there is no way out of it, that a judge says that I will take some sort of action against this person who has spoken a lie, or the person has committed the transgression of not really understanding what they are speaking before the court. And I thought I wanted to make a video about this because I have myself been guilty on earlier occasions of blatantly just blurting out, ABC is the thing or XYZ is the thing, and without knowing 100% sure that whether this is the case or not. And a very valuable lesson for all of us is that if we are not 100% sure, let us mention that before the court. A lot of occasions I have suffered these consequences, and because of which I try to be on most days extra vigilant about what I am saying to the court, as should you. Whatever you speak that to the judge. So on a lot of occasions, if I'm not 100% sure, but I am quite sure, I will say this, that I'm not 100% sure, but I think that this is the answer. And the other side, or the police, or the prosecution, the defense, whoever side is there on the opposite side, or the defendant, the plaintiff, whoever it is, the opposite side should correct me if I'm wrong. And if I am wrong, I will be corrected. And if I am right, they will not speak anything else. But if I am wrong, if I say something very, very concrete, such as XYZ thing has not happened, or this person has not sent me any, call recording or any audio recording, then there is a little bit of possibility that I might get myself in trouble. As an advocate, I might get myself into a little bit of trouble where I earn the reprimand of the judge. Perhaps the judge notes my conduct in the order sheet and perhaps imposes a little bit of fine as well. As a party in person makes a wrong submission, maybe on oath or maybe in front of the judge, he could be prosecuted for perjury, perhaps. Advocates can as well. But investigating officers, police officers, if they make incorrect submissions, either as a mistake or as a blatant lie, what happened in this particular matter, the DCP of the area concerned was summoned by the Delhi High Court, which is a huge thing for those of you who do not understand. When the investigating officer goes to his superior, the SHO, and the SHO has to go to the ACP, and then the ACP has to inform the DCP that the one of the top bosses of this area, the person who is supposed to be overseeing things from bird's eye view, you have been summoned to appear before the court and cut a sorry figure is something which will have huge repercussions, not just for the investigating officer, but for all of those people in that line of hierarchy. And by it, and I know what's going to happen on the next date of hearing. The judge is going to tell the DCP that you better get your people in line. This is what had transpired on the last date of hearing, and this is an informal warning that I am issuing to you. But this, in government departments, is more than enough to rattle many, many feathers. And so a very, very valuable lesson is, whether you are a police officer or a lawyer or a litigant, you have to be 100% certain about saying something. If you're not 100% sure, say that you're not 100% sure. It is far better than to rock the boat by taking this kind of a risk. The statistics, sure, go your way, but I say, why take the risk? Play it a little safe, especially when you are coming to court on a very, very regular basis.